Well, good morning, everyone. I am April DeFalco, the Outreach and Engagement Specialist for CTCPAs. Just as a reminder, you'll be receiving four pop-ups on your screen this morning during our presentation. You must respond to them in order to receive your CPE. And also, if you have questions for our presenter, please use that raise hand emoji down at the bottom on the toolbar or raise your physical hand and we'll get to you in the order we receive them. So I'd now like to introduce Robert Brody. In 1997, Robert founded Brody and Associates. It's a labor, employment, and benefits law firm that represents management and senior executives. Before Brody and Associates, Bob was a managing partner for Jackson Lewis, which is one of the largest management, labor, and employment law firms in the U.S. Bob is a trusted legal advisor to businesses and senior execs who need counsel on all issues involving personnel and has received numerous prestigious awards throughout his career for his work. Bob graduated magna cum laude with honors in economics from Kenyon College in Ohio, and then went on to graduate from Vanderbilt University School of Law in Nashville, Tennessee. Bob is licensed to practice law in Connecticut, New York, Michigan, Illinois, and the Mashantucket Pequot tribe. I knew I would trip over that one. And he's admitted to 9 United States District and Circuit Courts of Appeal. So, Bob, thanks so much for being here today, providing our members with your guidance on avoiding some of the most common mistakes made by managers. Let me turn the room over to you, Bob.
Well, thank you so much. It's a pleasure to be here, everyone. I look forward to your participation. I will tell you all, I'm going to give you all one piece of advice. The Mashantucket Pequot Bar, I was one of the last people who took that exam because after I took it, as long as you were a member of any state bar, you could appear in that Indian tribe. The hardest test I've ever taken in my life was that test because it was 30 years after I graduated law school. And they were asking me all this stuff from law school classes that I hadn't touched in 30 years. But anyway, I did finally pass.
Congrats.
Anyway, all right. So let me start off by just saying, why do you care about employment law? And there's really two reasons, I think, for you. One is you run businesses, some of you. And to the extent you run a business as a managing partner or whatever it might be called, um, you want to know this stuff for your own business. But the other is you're a trusted advisor. And I find advisors love it when I come in and I say to them, I know I'm a labor and employment lawyer. I help you with personnel. I go to court. I go to administrative agencies. I do all that. But I find they really appreciate when I say, but you ought to check that tax issue out. Go call your accountant or that corporate issue or whatever it might be. I don't know the answer, but when I can put them on notice that that just sounds funny, I think they really appreciate it. So that's one of the things. Hopefully, you'll get both those things out of this today. Um, and forgive me, my order of uh, comments came in the backwards way. But so my first point about are you just accountants? That's that point. And then we talked about what the employment law is. So let me just go into. I've got like 12 more slides that talk about various parts of the employment relationship, where it starts with hiring and it really goes all the way through to the end of the relationship. And I'm gonna ask you if you have questions as we go to let me know. So first of all, you get at the very start of it. Um, I didn't even mention it, but you got to obviously be careful about your applications. When there used to be newspapers that were paper and you could touch them, you could still see advertisements that asked for men or women or boys and girls, literally. And this wasn't that long ago. So people sometimes do things that don't make a lot of sense. Um, you want to make sure there's in almost every, not almost every state, probably half the states, including Connecticut, there's ban the box. Are you familiar with ban the box? Anybody? Ban the box is basically the rule that says you're not allowed to ask somebody if they have a criminal history until well into the application process. The only reason that's relevant for all of you is every application I'd almost ever seen asked the question, have you been convicted of a felony? You can't have that question on your application anymore. You can still ask it, but you got to ask it further down the road. So that's ban the box. Make sure that you've taken care of that. The other thing is salary inquiries. They're talking about pay transparency. It's a new thing. Over the last 5 or 8 years, they basically have said there is a history of women getting paid less than men, and you've all seen the statistics. And one of the reasons that is perpetuated is because I say to you, "Hey, applicant, what's your last salary?" Well, the historic less salary for women just is perpetuated because I keep asking about it. I'm not allowed to ask that anymore. So you need to make sure whoever does your interviewing knows that and they don't ask that. Now, one thing you can ask is, what do you want? But you can't ask, what did you get? All right. Um, Job requirements. One of the things you just need to be careful of is, are your job requirements accurate? And even for you as a managing partner, you want to make sure that, for example, if you're looking for someone in the mailroom and you say, look, we have a mailroom, they have to be the one who lifts, and so they need to lift a heavy amount of weight. Is that realistic? In many cases, the answer is it's not. But if you put that in there, it's going to be actually an inaccurate job description, and it could be the basis upon which someone sues saying, you wouldn't let me in because I couldn't lift 100 pounds, but nobody lifts 100 pounds. Very true in the manufacturing and in warehousing true situation. All right. Be careful of Google searches. There's nothing wrong with you doing a Google search on me, but if you do a Google search on me, you may find out that I'm Muslim. You may find out that I'm gay. You may find out that I'm whatever. And if you think about it, there's nothing wrong with any of that. But if I then accuse you of not hiring me because I am whatever you found, it's going to be hard for you to prove you didn't do that unless you can say, I didn't know. Now, you look at me. I mean, you may think I look gay. You may think I look Muslim. It doesn't really matter. Sorry about that. But whatever it is, you can easily say, I didn't know. Once you do the Google search, the only way you say it is if you're not telling the truth, and that's not an idea that we want to follow.
Bob, we have Mark Winnick who has a question.
Sure.
Yeah,
Shoot.
yeah. So if I have a job application out there on, say, ZipRecruiter, for example, and I get a bunch of, applications in, I look at the application and then I go look at Google, and let's just say, I find a report that somebody committed shoplifting. Well, that's not the kind of person I want in my firm that's dealing with clients' personal financial records and social security numbers and so forth. Are you saying I can't, I still have to interview them, or I could just not set them up for the interview? Could I just weed them out at that point?
Here's going to be the problem. It's more, unfortunately, it's more involved than you might think. The truth is, I was caught shoplifting when I was 25. Okay, that's irrelevant to today. No matter what anyone says, the government's never going to accept that. On the other hand, I was caught shoplifting last week. Well, that may be, that's relevant. So one question is whatever you found relevant based on time and based on the job? Now, for example, just so we're clear, I want to be the receptionist at your accounting firm. I don't really deal with much of anything in terms of private stuff or proprietary or confidential. So
Oh, oh,
you got
yes,
to,
you do.
well, okay. I mean, I understand you. I may be packaging tax returns, and so that may be
Yeah.
true. But I'm just saying, make sure that whatever you're saying is in fact relevant. And then the final thing is, I'm telling all of you, and forgive me, you should never lie. But you don't always have to tell people everything. So to me, I might not pick that person's resume. I just I wouldn't pick the resume. And that would be all there was to it. Would I focus on the fact that it was because of the shoplifting? No, I'd probably avoid that. I'd try to figure out some other reason if I was ever asked. And the truth is, you'll probably be able to, there's a lot of people you're not going to pick. You're not interviewing everybody. So
So
I
let's
wouldn't document it at all.
yeah. So let's just say I was hiring for a CPA.
Hmm.
He met the requirements, and within the past year, I found out he had committed unemployment fraud. Okay. To me, that's not a ethical, responsible person who's following the code of conduct,
Yep.
professional conduct. Okay, so I just tossed that into the wastebasket. I'm assuming I don't have a problem. He calls up a week later and says, "Did you get my Did you get my application?" Or I posted my application on ZipRecruiter. I didn't hear from you. I see you're hiring. What's this? Are you interested? Now what?
For all of you, again, I don't want to get into any details. So the answer is, did I get your application? Yes. What's the status? We'll let you know. If we're interested, we're going to be sending out letters asking for second interviews or emails or whatever in the next couple of weeks. And so if we're interested, we'll let you know. Thank you very much for your application. Have a good day.
Okay.
We're done. We're not going to have a conversation about it. Good question, Mark.
All right. Thank you.
AI. I just want to mention AI for all of you. AI, some of you may be knowingly or unknowingly using recruiting tools that use AI. One of the things AI will do is AI will say, just for example, anybody who lives in this zip code, there's a disproportionate number of people who are getting arrested in that area for theft. So you probably should try to avoid hiring anyone from this zip code. Well, that's illegal. So you just need, and it's your responsibility, even if you're using Indeed or anything, if you're using some service and it uses AI tools, you've got to make sure the AI tools are lawful. So I just kind of throw that out there and be careful. You can't just rely on the fact that, I don't know, the recruiter, the service, gave me the information. That's your liability. Okay. So next, I just want to talk quickly about the concept of employment at will. All right. Valerie, I'm going to pick on you. Anybody who would come to a webinar like this and put a hat on, I won't fire. I won't employ. And therefore, Valerie, as your employer, I'm firing you. And that's my reason, because she put on a hat. Am I allowed to do that? Yes, I am. I'm insane. We can all agree with that, okay? But there's nothing wrong with it. If her hat said, I'm Jewish, I'm a Christian, I'm disabled, I'm a something or other, then it's not a hat. Then it's an indication that she has some kind of legally protected status. But that's just a hat, which happens to be lovely, Valerie, and I would never fire you for it. But that is something you can do, right? So you always want to make sure you maintain that employment at will. As soon as you start making offer letters that say we're going to hire you and we are going to guarantee, we're going to give you this benefit, for example, with no reservation of we can change it, now maybe you're making a promise that you will always give that benefit, which you may not want to do. Or you'll say, I'm going to give you a job and we're going to have you work for, I'm going to guarantee for the first year you're going to be with us. I don't know that you really want to guarantee me a 1 year job. It probably isn't a good idea. So the bottom line is, make sure you're not making an offer in your offer letters that you don't want to keep. And generally, we don't make any offer in our offer letter that's specific. We're going to employ you. Here's the benefits we generally give, that kind of stuff. So it's all loose enough that I can say the next day, you know what? The roof collapsed and I'm going to change my mind. I'm going to withdraw the offer, and legally I can. The one thing I do say today is restrictive covenants. Those are the things that say you can't poach my customers, you can't poach my employees, you can't compete against me. You got to make sure you check in the state, because different states have different rules. but generally covenants not to compete are usually allowed if they're done reasonably, meaning in terms of duration and in terms of um, geographic scope. So, for example, if you wanted to say you can't go to California and be an accountant, and you have a local regional firm, no one's going to enforce that agreement. That's ridiculous. But if you want to stay, you can't stay in the same town and be an accountant, well, that probably is going to be. So I just want to make sure you understand, are there restrictive covenants out there? And has your employee applicant, are they bound by one? Because keep in mind, if they're bound by one and you hire them, now you have a problem. You want to make sure your applicant confirms to you, I don't have that. Anybody got a question about that? Okay. Misclassification of workers. This is a huge thing today. Most employers seem to be running into it, unfortunately. There's two different kinds of misclassification I want to talk about. And all of this falls under what I call the wage and hour rules. First of all is the idea of an employee versus an independent contractor. An employee, that's the person who gets the W-2. That's the person who you control. You tell them what to wear. You tell them what to do. You give them a computer. You give them everything. You pay for their continuing legal education. You do all that. That's an employee, and that's fine. And for most of the workers in an accounting firm, you're probably going to have professionals. And we'll get to that in a second. But so those are all employees. There are also independent contractors. Independent contractors, I'm an independent contractor. If you hire me, I'm going to tell you a secret. I do your work at 2 a.m. I'm usually wearing shorts and a t-shirt, and I'm sitting on my backyard. And there's nothing wrong with that. And sometimes I don't even do your work. I give it to somebody else to do. All of that's fine because I'm an independent contractor. You don't have the right to tell me where to be, what to wear, etc. I would just urge all of you, if you go into companies that have all independent contractors, that's a huge red flag. There's no way that that's true. I just did a big deal with someone who was buying a company, and it was like a $130 million deal. But the big issue was they had almost no employees, and they had 100 workers. And we told them before we even got involved, I said, there's no way. There's no way they're not independent contractors. And there's a lot of liability if you misclassify someone as an independent contractor when they're really an employee. So it's a big deal. Please do the same thing if you're in your own firm and you have a bunch of accountants. You have a little more flexibility, frankly, with CPAs. You could probably use more CPAs as independent contractors, but I would get some legal counsel to make sure you're properly classifying them. As you can imagine, if you do it wrong, you're not withholding taxes and you're supposed to. You're not giving them benefits everyone else gets in the firm and you're supposed to. You're not paying unemployment. You're not paying workers' comp. There's a ton of things you're not doing. So you want to make sure you're on top of all that. So that's employee versus independent contractor. And the bullet point here is, as I've been at least saying a little bit, hopefully directly, it's really a question of control. I tell my employees exactly what to do, and I can't tell my independent contractors what to do. I can tell them I want the job and I want the product and I want the quality, but I can't get into all the details of exactly how they do it. Anybody got any questions about employees versus independent contractor?
We have Mark with a question.
Yeah, so on the independent contractor issue, so, sometimes, we do have seasonal employees that come in, and sometimes that seasonal employee is not a CPA, but they've worked in accounting firms in the past, and the question is, are they an employee or an independent contractor versus a CPA who comes in and is a seasonal employee as well. Both of them kind of pretty much make up their own hours as to when they come, when they leave. They actually come into our office, use our computers. So the question is, does it make a difference? Can they be an independent contractor versus a employee?
I don't think the fact that they're a CPA or not a CPA is going to be decisive in this.
Okay.
But I'm not happy with the idea that they're in your office, so therefore they meet your dress code, whatever that may be. They use your computer, not their own. They have all the software that you give them. Now, these days, especially with accounting firms, a lot of times you guys have very intense amounts of software, but the independent contractor has full access to your software. Are they able to basically subcontract out the work? I'm going to bet the answer is no. They got to come in. So I might, chat a little bit more, Mark, with an attorney about that one. And I'll bet you, by the way, during the season, the tax season, there's a million, there's a million violations, especially frankly in the accounting world, because the pressure's so big. And I'll bet you that a lot of people have independent contractors who may or may not be independent. So I would double check that.
And can I ask one question going back to the restrictive
Yeah.
covenants?
Yep.
I raised my hand, but I didn't get it up there fast enough.
I'm sorry.
I already forgot what my exact question was on the restrictive covenant, but I thought there was I don't know if it was at the federal level or at the state of Connecticut level, I thought they were putting a ban on restrictive covenants.
They were. The federal level, at the end of the Biden administration, the FTC put a ban out that basically was saying in most every case a non-compete's going to be illegal. And then there were a bunch of lawsuits that were filed protesting it. And then the Trump administration came in and they stopped trying to enforce that rule. So, yep, you're right. It was on the federal level, but it is no longer there.
So restrictive covenants are okay in the state of Connecticut,
And across the country,
as
unless
long
there's
as
a
they're
state law.
reasonable.
Yeah.
Yep. Okay. Thank
All
you.
right. By the way, do pay attention if you're talking about your clients, because there are special, especially in other states, but even in Connecticut, there are some specific restrictions on like healthcare and doctors and nurses. So they have a special rule that's different than an accountant, for example. So just pay attention to that. All right, exempt versus non-exempt. That's in a very simple sense. That's just simply the question of, do these people get paid overtime or not? Just like the independent contractor situation. If somebody says to me, all of my employees are on salary, I don't pay anybody overtime, they're doing it wrong. There are there's 5 basic classifications of who's exempt from overtime. Your receptionist is not exempt from overtime. Your mailroom clerk, not exempt from overtime. The person who stuffs the packages together and sends me the questionnaire for my taxes and stuffs the tax return once it's done and all that stuff, that's not an exempt position. So if you're using the concept of salary to avoid paying overtime, you need to have that analyzed, because that's probably not legal. Okay. Let me go. Oh, here we go.
I thought there was once you paid over a certain amount of wages, they could be exempt. I'm talking about the secretary, for example.
No.
No?
Nope.
And why is it? I thought there was a special provision for that.
There's
based
not.
on wage.
I think people get it confused. If you're going to be exempt, you have to receive a certain salary. And there is an exception actually for accountants, but the general rule is you have to receive a certain salary,
Right.
in order to be exempt.
Right.
But just because you receive that certain salary, that doesn't make you exempt. There's 2 pieces to the test. One, are you paid properly? The salary thing is it. But the other piece is what we call the duties test. So I'm a lawyer. By definition, I'm a professional. Therefore, I can be exempt as long as the salary is right. Okay? But my administrative assistant who answers the phone, She gets a salary. I pay her $200,000 a year. She's not exempt because her duties do not meet the classification of what's exempt, even though her salary does. Two-part test, people often get the two confused.
So is it because she's not a professional
There's five
or the duties?
classifications of what is exempt, and there's really more, but there's basically five basic ones. She doesn't meet any of them. She's not a professional because that has to
Okay,
do with
so if she has
education.
certification as an administrative
Eh,
professional, that doesn't work?
it's not enough. It's not enough. If she had a 2-year degree, maybe. If she has a 4-year degree and she is doing what she got the degree in. So in other words, my assistant, she actually has a PhD in music. It doesn't mean anything. We don't do music here.
Right.
Now, if I was a music school and she was a teacher and I said I want her to have a PhD, that would be different. But in a law office, the fact that she has a PhD in music is meaningless. So she doesn't meet the classifications. I mean, you know what? I'm going to move on, but I will just tell you, April, if your group is really interested in this stuff, there's a lot to this, and I'm just hitting the surface.
Sure.
So, we can talk about it another day if you want.
Yeah, that'd be great. Thank you.
Okay.
So let me go over some pay practices. Just a few things. One, it's very common for employers to say, "Don't tell anybody about this. Wages are confidential." It's a great idea. It's illegal. Can't do it. So be careful about that. Employing minors. I don't think we do that a lot in the accounting field, but there are a lot of like restaurants that have minors, and the penalties, the federal government is hitting you with penalties that are significant. Um, the penalties can start off at $17,000 for one mistake. So the penalties are huge. You got to make sure everyone understands what the rules are. I'll simply say, if anyone is employing someone who's under 18, make sure they are checking the Department of Labor for what that person can and cannot do and when they can work, because it's two different things. There are hours. You simply can't work a 15-year-old 40 hours a week during the school year. You're not allowed to. And if you go past a certain hour, most states it's like 7 p.m., then you're going to be violating another law because you're working them a time when they're not allowed. So just make sure you double check if you have minors working for you or for somebody else. All right, in terms of some other pay practices, pay frequency is a big issue. That's not up to you. Generally, it's every week. Sometimes it's every 2 weeks. Twice a month is a problem. You should double check. You're going to have to make sure their pay frequency is allowed under the state law. Systems for correcting mistakes. A lot of people will just say, Charlie, you forgot to check out last night, so I know you left at 6, so I wrote it down and I corrected your timesheet. 2 months later, Charlie gets fired for theft and he says you're stealing from him because he worked till 10 o'clock that night. And you say, no, you didn't. Here's the proof. And the proof is your signature, but not Charlie's. And Charlie says, yeah, you always sign me out when I'm still working. You need to have a system for correcting mistakes that will withstand scrutiny from the government, which basically means the employee should be signing something. Voluntary payroll reductions. Connecticut's pretty loose. New York is very strict. You always should have an employee signing off on any kind of payroll deductions other than like taxes. But in some states, just beware, you're not allowed to make a payroll deduction even if the employee agrees. New York State's very strict on that. So it's just an issue you need to, again, I want to remind everybody, I know I'm going through a lot of things. The purpose of this is just so you will know enough, hopefully, to be able to say, I heard some guy say something about that. We should look into that. That's all I'm really trying to do. You're not, we're not trying to make you, I don't want you to replace me, please. But I do want you to at least have the sensitivity to be able to say, I don't think that's right. And then this is something that's forgotten by a lot of people. There are a lot of payroll forms that you may use. Many of them have to be approved by the Commissioner of Labor. Now you send the Commissioner of Labor and you say, here's my form, and the Commissioner of Labor will never respond. You've done your duty, don't worry about it. But if you don't have that request from the Commissioner of Labor, then you've clearly violated the law. So I'm just saying, you know, any forms you're using that are payroll related, you got to double check. You probably have to get them approved by the Commissioner of Labor in Connecticut. And it's the amount of scrutiny is whatever's closest to zero. I mean, they pretty much let you do whatever you want, almost, but you just need to do that. Okay. Questions about any of the pay practices?
Yes. Bob?
Yep.
Larry Kearney, which state's laws apply if employer is located in one state and an employee lives and works in a different state?
Oy, that's my answer. Oy. Ever since COVID, this has become a huge, huge issue. It used to be pretty simple. It was almost always going to be wherever the corporation is, but that's not true anymore. So right now, if you have remote workers, you generally, and there still is a huge controversy, you generally should try to follow the state where they live. Now, if you have a remote worker and you have an office and you do work in that state, let's say you have somebody in Pennsylvania and you do a lot of Pennsylvania work, well, there's no question there. That's definitely Pennsylvania, guaranteed. But we have clients and we've researched it, and they have a Pennsylvania person who only does work in Connecticut. We still think you got to follow the Pennsylvania law. You've got to, and again, this is more your area than mine. You got to register to do business in Pennsylvania. You got to pay the taxes. You got to pay unemployment. You got to pay workers' comp, all in Pennsylvania. So it is a pain in the neck. I'll overshare a little bit with you. My business manager, she's been in Rhode Island for the last 15 years. I pay taxes in Rhode Island because of her. I don't do any business in Rhode Island. The only thing I do is her body sits there and she works for us from Rhode Island. So it's a tough issue, but generally speaking, without knowing the facts, I'd say you're probably going to get stuck with that foreign state's laws and taxes and registering to business.
Bob, I have one more. Marjorie, what are examples of which deductions EEs must sign off on?
So one I would do is even health insurance. I have people sign off on health insurance. If you have a 401k, I want them to sign off on what the 401k is. If you have what do you call it? Taxes. No, you don't need to have them sign off on any kind of taxes. If you give loans to your employees and you want them to pay you back, they got to sign off on that. If you have swag, there's the firm, the company's store where you can buy shirts and this and that and the other, and you have somebody where you'll take it right out of their paycheck, they got to sign off on that. So really, the way I look at it is, if it's not a tax thing or something the federal government mandates, probably are going to have your employees sign off on it. The only exception is there are some states that don't have this rule. I think you're crazy not to have the employees sign off on it anyway, but they don't mandate it. Connecticut does. Connecticut, you absolutely can't take any money out of the paycheck unless you have them authorize it. Any follow-ups? Any other questions? Okay. All right, so let's talk about privacy. At our firm, again, I'm oversharing. When you open up your computers at Brody and Associates, the first screen you see says, this is Brody and Associates computer. Anything on here is Brody and Associates. You have no expectation of privacy on the computer or anywhere else in the firm. And you should all have that. That also should be, to the extent you have a handbook, it should be in the handbook. I tell people here, if you are on vacation and I think that there's something or other in your desk drawer that I need because you left a piece of something that, you left a case in your desk and whatever. So I'm going to go in your desk and I'm going to see if I can find it. or whatever it might be. And when I find white powdery stuff that happens to be cocaine, you're in a lot of trouble. But I have a right to do that. I don't need cause. I don't need anything. Um, Same thing on the computer. If I look on your computer and you're looking at porn sites, you're gambling, you're doing whatever, it's my computer. And there's nothing wrong with me looking at my computer. So you just want to make sure that people understand, especially in today's day where so much is on the computers. That computer is not yours, employee. It's the company's. And similarly, so is the desk and the chair and the closet and everything else. I tell people, I've been running this firm for, I don't know, 30 years. I don't know. I don't think I have ever gone into anybody's computer unless I was looking for a document. So it's not like I do it a lot, but I could. And that's the way I like to put it, because the truth is I'm not going in anyone's computer and I'm not going in anyone's desk drawer, but I could. All right. Electronic monitoring. Some states, including Connecticut, require that you have a notice that tells people if you're monitoring them electronically. If you have a key fob to get into your office, you are monitoring them electronically. If you can tell when they sign on their computer, you are monitoring them electronically. If you listen for quality control to the customer service reps who are on the phone, or you listen to the guy who takes your order at McDonald's, all of that, electronic monitoring. So you have to have a notice that tells people we have surveillance cameras or we listen or whatever it is. By the way, this should, in case it's not obvious, you can monitor, you can use surveillance cameras. They cannot be at a place where people are going to be expecting privacy for purposes of getting changed or going to the bathroom or something like that. And then the final thing is just you all have a boatload of notices that you are required to post. I always struggle with what do you do with people who are not in the office? If you have a website and you can give them access to the website and all of your notices are on your website, that's great. If your notices are behind the clothes in the clothes closet in the front hall of your office, that is not appropriate, even though I literally saw that from one of our New York clients. So please make sure you have them someplace where they are visible and also make sure they're current. I know people who have federal signs of minimum wage at $4.25. That's a long time ago. Okay. Okay. So we got verification number 3. Hopefully you guys are seeing this and submitting them. All right. Training. Many states require training, including Connecticut. Sex harassment training is a big deal. Got to have it 2 hours. You can use the state provided one, which is not really very good. It kind of says your employer is going to try to harass you. Here's what you do when it happens. It's pretty negative, but it's free. Then you can go to people like us. You can go to other online services and you can get training. So just remember, you need to get it. Some states require slightly different training for supervisors. But again, just double check it and make sure there is some kind of training going on. In terms of evaluations, the one thing I will tell you is if you care about unemployment, you need documentation to win an unemployment hearing. Unemployment is not a well, let me say what it is. Unemployment is an income redistribution system. It's a socialist idea. Forgive me for being political, but it is. It's not a you deserve this. It's not what it is. You don't have a job unless you did something horrific. The government's going to pay you some money. So when I fire you because you can't add, you're going to get unemployment. People don't realize that. So that's just the way that system works. If you're going to try to ever win an unemployment hearing, you need documentation. You need good documentation, clear documentation, so the employee knows that they shouldn't have done whatever they did. Whether or not you want to fight unemployment, I will tell you, as you guys probably know, a lot of companies don't even bother. But that's your choice. The only thing, my last point about the misleading evaluations, There are lots of times when people get fired and we look at their file, and some people say the worst thing is there's nothing in the file, but that's not the worst. The worst is there's something in the file and they're all good reviews. And then you fire the person for incompetence. It's like, what are you talking about? Guy's never gotten a bad review in his life. And that's our mistake. And the halo effect, the only thing I want to remind you is I may be a idiot savant with numbers. I am a genius. I am amazing. That doesn't mean everything about my performance is good. So you want to make sure that just because you do think, and I may be your best employee, there still are things that you want to talk about with me. And so you don't want to just say he's great unless he is great in all fields. If there are areas where I'm weak, you got to tell me that. So don't let people think just because I'm, great at whatever, I'm great at everything, because that's not true. Okay. Onboarding. I'm just looking at the time. Okay. Keep in mind, if your payroll company probably does most of this stuff for you, but you got to double check. Every state just about requires that you send a notice to the state saying you hired so-and-so, here's so-and-so's social security number. Your payroll company does that. If not, you need to do it. There are lots of mandatory notices that states require. You can go to your Department of Labor and see it, but there are many notices that when a person gets hired, you got to give them a notice. I'm just telling you, you should check that. Misleading job descriptions. The only thing about misleading job descriptions I will tell you is, one, if they're misleading because you have requirements that you don't enforce, I would be careful and get rid of them. So everybody has to be a CPA at your firm, but that's not true. You got a bunch of non-CPAs. You don't want to have that in your job description. The other thing about it is, at my accounting firm, I tell people we work an even week. Every week out of the year, we put in 40 hours. We never put in more. I assume you all realize that's a lie, because there's no way I get through tax season like that. But even though it's not illegal, it's crazy to mislead people, because when they get the truth, they're going to quit. And you've just spent a boatload of money and a boatload of effort hiring me. And then I'm going to say, what the hell do you mean you want me to work 60 hours during tax season? And then I leave you in the lurch. Doesn't make sense. We are big fans of structured orientation programs. I think there's a lot of good stuff you should tell people during orientation. You should sell the company, but also warn them about the realities. Tax season stinks. That's just the way it is for a lot of accounting firms. In your world, as accountants, I probably wouldn't mention unions, but I would mention unions in terms of manufacturing. And that's a big issue. We do a lot of work where we help companies stay union free and deal with unions if they have them. A lot of people believe the idea is, you're the ostrich, stick your head in the sand, don't say anything about that topic. We find that doesn't make sense. So we're much more apt to urge you, talk about the weaknesses in the business, talk about the threats, including unions. In an accounting firm, I wouldn't do it. And then finally, keep in mind, when you hire someone, you should have an offer letter that lays forth all the basic terms of their employment. Here's payday, here's what you're going to get paid, here are the benefits, blah, blah, blah. All of that should be there. You're required to. Most states require that. Not all. Connecticut does. So make sure you have a good letter that documents what they're being offered. All right. In terms of offboarding, when you fire somebody, keep in mind, the final paycheck's got to be timely. If they quit, it's in the regular pay cycle. If you fire them, it's the next business day. Some states say it's the day you fire them. So just make sure you know what that rule is and follow it. Even with your payroll company, they can tell you, here are all the deductions, here's how much it will be, and you can write the check, and you can write all the deductions on the stub of the check, even though you don't normally do payroll, and you'll just do it on one of your regular checks. So you can get it done the same day if you have to. Figure out if you have to pay any accrued benefits. For some people, for some states, you do. Most states, you really don't have to pay many accrued benefits. You have a policy that makes it clear you don't pay PTO upon departure, you don't pay it. The deductions from the final paycheck is the same thing we talked about before. The employee has to give you permission. And you, one of the things that we do is we let people borrow PTO, but on the borrowing PTO form, it says, I have 2 days, I want to take off a full week. I'm going to borrow 3. And on the bottom of the form, it says, if you leave before you pay back the 3, we get to take the whatever you owe us out of your final paycheck. You can't get that signed when the person hires on. It's got to be timely. So you got to have that kind of authorization around the time the person incurs the debt, so to speak. All right, a 5-day letter. I just want to make sure you all know. When somebody leaves for almost any reason, you need to give them a letter saying you've left our employee, your last day was, you're not getting, your health insurance ends on, and here's the unemployment paperwork. Your clients probably aren't doing that. Many of you may not be doing that. It's something that falls through the cracks a lot. Medical coverage, there is COBRA. There's state and federal versions of COBRA. So your employees will be able to continue at their own cost and maybe even a little bit more health insurance. Final point I would say to all of you, despite what you think of your employees, workplace violence unfortunately continues to be an issue. So I always tell people that when that 100-pound wimpy guy is getting fired, don't assume that he's a 100-pound wimpy guy. If he's got a gun or a knife, he is bigger than you. And I always assume that the person has a gun or a knife. As horrible as that is, I think you need to assume that. So just for example, when I have a conference room and I'm going to let you go, I'm going to fire you, I sit next to the door. You sit on the other side of the table. So when you stand up and say, I'm going to kick your butt, I can run out the door. If I'm on the other side of the table, I can't get out of the room. Think about that. I know it seems, dramatic, but I think you should consider that. All right. I-9s. Is it illegal to hire an undocumented worker in the United States? Is it? The answer is no, it is not. It is illegal to hire them knowingly. And the I-9 form, just so you all know, is a federal document. We got a little copy of it up here that you are supposed to fill out for every person you employ. If they're an independent contractor, no, but if they're an employee, you have to. There are ways of filling it out. You have to be very careful. If you put the date in the wrong format, if you write June as opposed to 06, you're wrong. So it's a very technical form. Otherwise, it's not that hard to fill it out. You do want to make sure you complete them properly. You do want to make sure you file them separately from all the other personnel documents, because the government has the right to come in and inspect them. So you want to be able to pull them out and just give them the I-9 forms, not everything in the personnel file. I-9 forms, there are specific rules about what kind of documentation is valid and what kind of documentation needs to be updated. If you prove you are eligible to work in the United States and you give me a valid passport and it expires in the following year, there's nothing more that needs to be done. You're fine. But if you give me a green card and the green card expires the following year, you need to put an update on the I-9. So you really got to look at this stuff. I would just urge you all, make sure you pay attention to this. If you have any issues with it, especially with the current administration, there's a lot of stuff going on with immigration. A lot of there are raids. If an employer knowingly does bad stuff with the I-9, they can go to jail. If you'll forgive me, you're just a dummy. You just did it wrong. You didn't pay any attention. You're not going to jail. Technically, yes, you could, but I don't worry about that. If you're knowingly doing it, this stuff's really serious, and I would Be very concerned for you. I finally just want to mention, I know a number of people who have said, oh, with all this stuff about immigration, I'm going to now, I'm going to redo all my I-9s to make sure they're good. You're not allowed to do that. You can only redo an I-9 if you have to. And I'll just ask you, in case you have a client, because I just had one who just asked me this, they want to redo all their I-9s just to make sure, you can't do that. All right. Under this administration, there are no match letters. But as you may be aware, for a while, the Social Security Administration would send out a letter saying, you said that Bob Brody, Social Security number 123456789, works for you. We don't have any Bob Brody with that Social Security number. There's always been a question of, do you have to really do anything with it? The consensus is generally you don't. Right now, it's irrelevant because this administration isn't sending out those letters. But if they do, the question will come up, do you have to respond? And the answer is generally no, but I would keep getting counsel because that changes. All right, I-9, that's a lot to talk about.
Bob, we have a question from Donna. Do
Go
you
ahead.
have to collect the updated documents when they expire? Did you just go over that? When an employee
Yep.
used the passport? Okay.
Okay.
Driver's license with new renewal date.
Okay, so it's two different things. If the thing that expires changes your status in the United States, you need to update the form. But the fact that my driver's license expired, that doesn't mean I'm not entitled to work in the United States. Doesn't mean I'm no longer a citizen. My green card, well, that may mean, yes, I am no longer allowed in the United States. A visa with an expiration date, that has to be updated. But those other things, they don't. The only thing you got to be careful of is they have to be current when you use them. The rule used to be an expired passport was proof of eligibility to work in the United States. That's not true anymore. It has to be current today. If it expires tomorrow, that doesn't matter. All right. We're running out of time, so I want to go quickly.
We've got a few minutes, Bob. We've got about five minute, another 5.
Okay. So first of all, I just want to make this point clear. DEI. The Biden administration was saying you should really push it and try to make sure that we're having giving lots of opportunities to people who are underrepresented, et cetera. And the Trump administration has issued an executive order saying that's illegal. The courts haven't really supported what the Trump administration is saying completely. But I will just tell you, if you have a client who is really committed to DEI and really wants to make sure that underrepresented people are hired and you give those underrepresented people advantages, the current administration is going to say that's illegal. As soon as the next administration comes in and as a Democrat and maybe even as a Republican, they're probably going to reverse that position. But this administration, they say it's illegal. Now, William Tongs, the Attorney General in Connecticut, he is one of the many Attorney Generals who has said it's not illegal. And you guys are caught on the horns of the dilemma. The state will let you do it, but if the feds catch you, they're going to say it's improper. If you are really committed to this issue, talk to your lawyer. You really should. Make sure you know where you should draw that line. Okay, reasonable accommodations. There are a bunch of different types of people who are entitled to discrimination in their favor. That's really what a reasonable accommodation is. So if you think about it, I am disabled. If I have a disability, there are certain circumstances where you as an employer are going to be required to give me more assistance than most people. So you might have to give me, for example, a computer that I don't have to look at. I can hear it. Everything on it is audio. Or if I have a visual problem, there's something else, or a hearing problem. If I have a bad back, you may have to give me a winch of some kind or a lift of some kind to do my job. There are things you have to do to accommodate me if I have a disability. This is an area where I really would tell you, If someone starts talking about it, get your lawyer involved. It's just it's very fact sensitive. It's very difficult to give you general advice. Pregnancy, another one. You got to accommodate. You got to give a woman who is pregnant more assistance than someone who's not. So I may say all of my salespeople walk around the floor, but I may have to give a woman who is a salesperson a high chair that she can sit in so she doesn't have to walk as much if her doctor says so. The one thing about all of these things, you're not doctors, I assume. You are not qualified, nor am I, to decide how to accommodate a pregnant woman or how to accommodate someone with a disability. You got to go to a person who knows, which is a doctor or a medical provider. But these are all cases where, accommodations are um, uh, needed under the proper facts. So accommodations generally have to be reasonable. And the one thing I would remind all of you is you should get legal advice. But if someone is asking for an accommodation, most of the states require what they call an interactive process. And what that really means is you sit down and you chat with the person. How can I help you? How can I help you do the job? And you can't just say, well, it's obvious you can't do the job. You're in a wheelchair. Even if you're right, you still have to go through that accommodation interactive process. You have to have a conversation. Again, if someone talks about they are owed an accommodation, I'd get your lawyer involved. Doesn't have to be a long conversation, but I would. All right. This slide, the reason I just throw it in there is if you go down to lack of civility, often that's what a lot of discrimination stuff comes up with. You look at my hair and you say, my God, you look like a bum. What kind of hairstyle is that? Well, in Connecticut, there's a specific rule, the Crown Act, that says I'm allowed to have an ethnically traditional hairstyle. So I have an afro that's out to here, or I have dreadlocks, or I have cornrows, or whatever. And as long as there's not a safety violation from the health code, or, like long braids that might get caught in machinery or something, I'm allowed to wear that hairstyle. And there's nothing you can do about it. So I just ask you to be sensitive. If you're looking at somebody and you're saying you don't look like an American, you don't sound like an American, those things are almost always going to be guaranteedly unlawful. And even English proficiencies. Do you really need to speak English? You might argue the answer is yes in your accounting firm. In a lot of your clients, the answer is no. So I would just ask you, be careful on this stuff. If what you're hearing has to do with the fact that I was born somewhere else or I'm different than most people, you just want to double check to make sure you're allowed to consider that. That's a 4-day seminar on discrimination in 2 minutes. So, what questions do you have that we haven't answered yet?
I believe we got all the ones in the chat. See if anyone's hands up here. Looks like you did a pretty thorough job, Bob. I don't see any other questions. Bob, will you be making these slides available? Could you send these to me?
I can.
Okay, and I'll get them out to everyone.
Yep.
Perfect.
If I could suggest to all of you, I hope this was very helpful to you. If you're getting into a really tough spot, I hate to sound self-serving, but call a lawyer on some of this stuff. It's not necessarily that hard, but I often tell people, if you're being logical, you're not necessarily doing it right. Because there's all kinds of stuff that to me doesn't make any sense, but that is the rule. So I just want you to be careful. I think you need to go to the Department of Labor website. I urge you. There's stuff there. There's a lot of stuff there. Call a lawyer. You can call us. I'm happy to just help you out. Obviously, it turns into a big matter. Sure, we're going to ask you to retain us, but will I give you 10 minutes on the phone just to say, hey, that doesn't sound right, or you're making a mistake? That's perfectly fine. Sure. But I just think you need to do that. And the final plug I will give all of you, you need to make sure you're getting some kind of legal update because there's all kinds of stuff that keeps changing. Law firms like ours, we add you to our mailing list. Every month you'll get it. If there's a big case in Connecticut, we pick it up. We pick up most of the big cases across the whole country, but in the tri-state area especially. So I would urge you, and as much as I'd love you to read our entire articles and all the stuff we write, forget that. Read the headline. If the headline's got nothing to do with you, move on. But if the headline talks about that Crown Act, you better pay attention because that's here. And you need to know that. So I really do urge you, make sure you're getting some legal updates. I think it'll really help you.
Bob, we actually do have one last question, if you have the
Sure,
time, from
sure.
John. Regarding employee versus an independent contractor, does the recipient's desire have any bearing whatsoever?
None. The
Easy.
government, the government doesn't care what you two say. You two say you're an employee, frankly, no one's going to argue. But if you two say you're an independent contractor, government hardly cares at all. They're going to go through their test. If the test says yes, fine. If the test says no, fine. Your desire doesn't matter. And by the way, in almost every case, if your employee and you agree to do something that the law doesn't allow, it's still not allowed. So, for example, if you said to me, Bob, I'll give you $800 a week, no matter how many hours you work less, more, for whatever, I'll give you the $800, and I say, fine. And most of your restaurant clients, by the way, this happens all the time. That's no defense. That's illegal. I owe the person overtime. Doesn't matter what I said, doesn't matter what she said. So if you're agreeing to something illegal, although you don't look at it that way, that's really what you're doing. It's almost never going to fly.
Bob, thank you so much for your time. Thank you, everyone, for being here. Very enlightening. Thank you so
Good.
much.
It's a
Thank you.
pleasure.
Take
Have a great
care.
holiday season, everybody.
You too.
Thank you.
Thank
Bye-bye.
you.
Bye-bye.